Hello, my name is Annie Manata. Welcome to my presentation of the topic damages and defenses. I'll start by defining a couple of terms. Damage is the third element in a negligence claim. Damages is what can be awarded when a tort has occurred, and this can be for a number of losses. There are times when there can be defenses to negligence, and we'll talk more about those as we go. In my topic today, I have a case study. I'll give you a brief background of the case study. Noxo Private Limited owns a refinery firm, and due to the negligence of one of the employees, there's an explosion in the pipeline. During the explosion, two of the employees of the company are injured, named Ray Bands and Mick McDonald. Ray Bands is 62 years old. He suffers from arthritis, and due to this arthritis, he's due for a hip surgery in some 3 years or so. But due to the injuries sustained during the explosion, the surgery has to happen immediately, so he'll need time off work. He already has some entitlements to leave without pay, but taking time off work now is not voluntary for him. He is also upset because he won't be able to participate in his favorite sport, which is lawn bowling. His doctors have advised that he has an 85% chance of being able to return to his sport. Mick is in his 30s, and due to the injuries caused by the explosion, his hands are injured, and due to the injuries, he's no longer able to do heavy manual labor. Mick was being considered for a promotion, and he will not be able to pursue that position any longer due to the injuries. Mick was also said by his colleagues to always wear his gloves, but they think that on this particular day, he wasn't wearing his gloves because he had gone out to lunch to the pub earlier and had a few alcoholic drinks, and so he forgot. But Mick stated that he only had one drink and he was fine, and the gloves were a requirement. They were a recommendation. They were not a requirement for the job. Another party that was affected by the explosion is a company known as Convert Private Limited. Convert owns a piece of land in the vicinity of where the pipeline burst, and they were planning to rezone that area for residential use. They had put through their applications of the plans and waiting for approval. There was no guarantee that they would get the approval, but because of the groundwater contamination caused by the explosion, they were definitely told they cannot be granted the plans, so they cannot go ahead with rezoning for residential use. So there's three parts to the question. I'll answer the first one. The first one is asking about the likelihoods of damage that will be claimable by Ray and Mick in the likely basis of calculation of these damages. Now, the purpose of damages is meant to cover the plaintiff from losses, and both current and future, and enable them to be put in the same position as if in the instance of a contract, as if the contract was performed, or in the instant of a tort like injury, as if the injury had not occurred. The Civil Liability Act of WA 2002, Section 5K, basically states that it is generally expected that a person should have done what a reasonable person would have done based on what the person knew or would have known at the time. Most of the rulings in these cases will lead toward mitigation, which is just reducing the loss as much as possible. There is a case, one of the leading cases in damages is in the case of Chaplin versus Hicks. Chaplin had entered into a beauty contest that was being run by Hicks and had sent through her photograph, and she had actually made it into the final 12. She came first in her section, but because she got the notification late so she could progress, she was not able to progress into the competition. there was no guarantee that she would have won in the end, but she decided to sue for loss of opportunity. The issue was to see if there was a breach of contract there, and the court held that she was eligible for compensation for loss of chance of opportunity. Because if she had progressed, she actually could have won the prize. So she won that one. In the situation with Ray and Mick, both Ray and Mick were owed duty of care by their employer, and they were also owed duty of care by the other employee, because you owe duty of care to your neighbor. Your neighbor is whoever can be affected by your actions. So that was breached. Ray's arthritis alone, without the injury from the explosion, would not have required surgery for a few more years. He wouldn't have had to take time off work during that time. And he wouldn't have had to take time off work without leave, because then he would have probably planned for this prior, but now he has to take time off work, which was probably not in his plan. So he should be able to claim for losses there. He can claim for pecuniary losses, which is the hospital bills and loss of income. And Mick can also claim for the same. He's eligible to claim for the same. Mick was not wearing gloves, but this did not cause the explosion, and this in no way would have contributed to the harm. So he cannot be held against contributory negligence in that regard. Mick was also being considered for a promotion. He's now unable to pursue that position because he cannot do manual labor. So he will be eligible for compensation, because if he can continue on the light duties, but they don't pay as much as what he would have had in the promotion, then he can claim for that difference. That's the mitigation. He can claim for that. However, Ray may not be able to claim anything concerning his favorite sport, because it's not mentioned that he was receiving any income from the sport. Part B of the question is whether Convert is likely to be able to claim damages for the lost opportunity of developing the land into residential houses and apartments. Convert already has evidence that they were going to rezone for residential use, because they had already made the applications. So there is loss of opportunity there, and there's loss of opportunity there. So damages can be awarded for property damage and for future loss of opportunity. There is a case of Glenmont Investments Private Limited versus O'Loughlin and a few other defendants that he was working with. In this case, Mr. Limb of Glenmont had an idea to build a life-size mechanical dinosaur. Construction began in the 1980s, and they would move it from place to place as it was getting bigger, and they needed bigger location. When it was done, they ferried it from state to state for exhibition at some shows. It was then ferried to Adelaide for a show, and he had made sure that there were fire extinguishers close by in case of emergency. And the show happened and it went on, so families would buy tickets to come and see the dinosaur, and it was almost alive. It could breathe and make groaning noises. And so when they had now contracted O'Loughlin and all of his colleagues that he was working with to dismantle the encasing which the dinosaur was being held, he was using his equipment to cut it open, and the dinosaur caught fire and it was completely destroyed. And so Limb or Glenmont was suing for damages, and the showgrounds were on the land owned by the society, so he was also seeking compensation from them. The issue was whether if O'Loughlin and the society were negligent. The court held that they were negligent because the team that were dismantling could have put out the fire using the extinguishers, and the society was held accountable because they were unable to put out the fire in that event. Furthermore, Lim sued for loss of opportunity because he said the dinosaur would have made more money because they would have done the same exhibitions in the US of A, and there was also opportunity for them to feature the dinosaur in some films. And the judge held that for sure they could have had the dinosaur in some films, even though it could have also amounted to nothing, but they could have had an amount amounting to about 100 million. So the amount was reduced to 90 million, which they could claim for that loss of opportunity. So in the case of Confit, they can already prove that they were already going for the residential zoning and there was loss of opportunity. They are eligible to claim for those for that property damage, first of all, and also for the loss of future opportunity. The third question is whether the liability of the company Noxo to make is likely to be reduced due to contributory negligence. So there's four main defenses that can be defenses against negligence. The first one is contributory negligence. The second is voluntary assumption of risk. The third is illegality, and then policy defense. The one we're looking at today is contributory negligence. Contributory negligence cannot be concluded if the plaintiff did not contribute to the actual harm. And in this case, the but-for test would be in question, and they would be asking if the injury would have been caused but for the person's omission. In the case of Campbell versus Willard, some students were going to a tavern to celebrate the summer and the end of exams. Mr. Willard was driving a boat where Kate Campbell was in with a few other passengers, and they went to the tavern, and on the way back around midnight, they had been drinking, the passengers had been drinking, including Mr. Willard, the driver, and they collided with a navigation beacon in the water, and some people were thrown overboard. Then it caused life-threatening injuries to Kate Campbell, and they were suing for damages, and she could have lost her life if not for emergency surgery. The court held that she was granted $230,000 in compensation for her medical costs and everything that she incurred. Also, she was going to be faced with some disability for the rest of her life. In another case, town of Port Hedland and Horder, a 23-year-old man with disability went to the aquatic facility there, and while diving, he dove from a block that was there. The block was deemed as dangerous as it was close to shallow water. There was already approval and funds for the block to be removed, but it was not yet removed, and they could not explain why. So he dove head first, and he sustained injuries that caused spinal injury, and he became a quadriplegic. So it was held that the town of Port Hedland was negligent, and he was granted compensation, but there was contributory negligence for 10%, because, well, actually there were no signs, and even if the signs were there, he probably, with the intellectual disability, would not have been able to comprehend. So Mick was without a doubt owed duty of care. This was breached, so damages should be claimed. And in this case, Mick was not the cause of the harm, and not wearing the gloves was just a recommendation, not a requirement, and he did not actually contribute to the harm. So he the company is not liable to rebut for contributory negligence in that regard. So that was the questions. So the answers are: Mick and Ray are eligible for compensation. Confit Private Limited are eligible for compensation for damage and for future loss, and Mick is also eligible to claim his compensation, but contributory negligence does not apply in this situation. Thank you for listening.